Ladies and gentlemen, welcome at this wonderful web lecture in which we will discuss the difference between legal positivism on the one hand and natural law on the other hand. Well, first of all, positivist law and natural law are two extremes on a gliding scale. They both express a fundamentally different idea on what law should be, on how we should organize just behavior. In the case of positivist law, we assume that law can only be law once it's written down, when it's codified. We need basically legal text to understand how we can organize just behavior. And before that, the law simply doesn't exist. An opposing view is that of natural law. In the case of natural law, we assume that law is already out there, is a natural thing that we can figure out through reasoning. It doesn't necessarily have to be written down. It can also just be what it is. Maybe an example of that would be helpful in this case to understand it properly. What about human rights law? We assume that each individual has a fundamental human right to live a life with dignity. We do not necessarily have to write this down first. We assume that this is just a natural state of affairs. And while it's written down or not, it's not relevant. We all simply have human rights for the mere fact that we are human beings. This is in our nature, if you like. These are two distinct ideas on law, and they both have their pros and cons. The pro of positivist law, for instance, is that we have a great deal of legal certainty. We truly understand what the law is because we can simply read it. And we can reasonably predict the outcome, the legal outcome of our behavior because we can actually read what we consider to be law. The obvious con of positive law is that if we need legal text to understand what's right and wrong, we might lose ourselves in these texts a little bit, and we may forget that there are such things as fundamental rights and fundamental things we assume to be natural. Well, for that, of course, we have natural law. The obvious pro of natural law is that we don't need written text to understand what's right, because it's simply right or wrong, and we can all act accordingly. The obvious disadvantage of natural law is that it might lead to legal uncertainty, because it can also be a little bit vague. I mean, what does dignity exactly mean? We just don't know. Maybe it's different per culture or per situation or per country. But it can also lead to difficult interpretations. So, both have pros and cons. Both interpretations are most of the times used in a society to create legislation. For instance, in most societies we have written codes or case law that are written down to understand what law should be, but at the same time we also have such things as fundamental principles and so on and so on. We simply use in our understanding of law. They are not necessarily written down, but we do use them. Natural law, that is. Well, I hope you've learned a few things from this web lecture. Thank you very much for watching.